Good afternoon, everyone. My name is Kathy Purdy. I am the Marketing Manager at Schoeneck King. I'd like to welcome you to this afternoon's webinar, Coronavirus Update and Discussion on Continuing Legal and Practical Issues Related to COVID-19. Two quick housekeeping items before we get started. Please submit your questions through the Q&A box located at the bottom of your screen, and those will be answered as time allows throughout the presentation. Once the webinar has concluded, please take a moment to complete the brief survey. We greatly appreciate that, as our attorneys do look them over and read them and appreciate your comments and suggestions. So to start today's program, I'm going to turn it over to Pete Jones in our Syracuse office.
Thank you, Kathy, and good afternoon, everyone. I see people are still sort of trundling in here as we open up the login. It takes a minute or two. So while we wait for people to get on, let me just give you a preview of our agenda for today. We're going to start off with Katie Anderson in Albany. She's going to do an update from Albany section. Once again this week, no shortage of developments. Then we're going to turn to the new DOL regulations regarding the FFCRA. People are familiar that there was a court case that called into question DOL's position on some of these issues, and so we're going to talk a little bit about that. We'll have Jessica Moeller and Teresa Rusnick talk through that. Following that, we're going to have Aaron Torsello talk about some recent guidance from the Equal Employment Opportunity Commission, some updates in that area, and then we're going to do a periodic feature that we do, a litigation update, just so people are aware of what's going on with Curtis Johnson in our Rochester office. So let's kick it off with Katie and the update from Albany.
All right, here we go. As always, we're going to start where we tend to start for the past few weeks with the travel advisory map. This has not been updated yet today. I was just feverishly updating all of my things. Even up until the moment Pete was done speaking, and it still has not been announced by the governor, which is marks the first time that the travel advisory states have not been updated until in the morning on Tuesday morning. Based on the numbers I have been looking at, it appears California will be removed from the list this week. That's not to say that that's true or that's going to be golden, but it appears to look like California, potentially Ohio, will be removed from the list. So that's, we will send out, of course, our weekly update with this updated map once we have that data confirmed. Next up, this executive order came out right before Labor Day, and tucked away in it was a provision that relates to the travel advisory. It says that if an employee, leaves for a vacation or whatever and travels to a state before it was placed on the travel advisory list and then returns after it's placed on the travel advisory list, that employee will qualify for state paid leave. That's a clarification of what the paid leave executive order had said previously. And so that's a little different. So everybody pay attention to that, because that is different. So again, if your employee leaves to go to a state before that state's on the travel advisory list, or when the state's not on the travel advisory list, and returns after the state's been added, paid leave applies. So that is different, and I am sure many of my esteemed labor and employment colleagues can tell you everything you need to know about paid leave. Next up, we have Executive Order 202.61. This came out last week, and this was a big order, and we are putting out an information memo on this, but because it's a big executive order, it's a lengthy memo that we're putting out. So first up, let's just start with schools. How does this order impact schools? Schools must report every day all COVID-19 testing and the diagnosis among students, teaching staff, employees, or volunteers. Next up, you have licensed professionals. And I'm going to go over what this means at the very end, so don't worry. Licensed professionals, so your medical providers that are doing the COVID-19 tests or flu test, now have to ask every time a person shows up there to take a COVID test, have to ask if the individual attends a school, if so, where does the individual work, and whether the individual works or volunteers at a school. Why does this matter? Because that information is now passed on to the laboratory where the test is being done. Those laboratories now must report to State Department of Health that information with the test results. So the way that the school dashboard, this school COVID-19 report card is going to work is it's complicated. First, you have schools that are administering their own tests. They have to report those tests directly to the state. Next, if it's just, a teacher who goes and gets a COVID test on their own time, that laboratory must then report that teacher's result to the state. That will be reflected on the state COVID-19, on that school's COVID-19 report card run by the state. So that's a complicated procedure, but hopefully that's how it's going to go. It has changed already in the first 2 days of its existence. So by next week, I'm sure that something completely different will be going on with how this is going, how these reports are happening. But that is different for everyone. It's different in all stages of the testing. It also applies to higher education. So even if it matters if the individual attends school. School in that case means K through college or law school or master's, any of those things. All of that applies. So that is a big shift from where we were a week ago. And moving forward, that's going to be something to watch. We are trying to disseminate lots of data. Finally, an update for municipalities. Boards of elections have to develop a plan that will allow registered voters to drop off their absentee ballots at the Board of Elections, an early voting location, or the election day polling place. And that line that the voters dropping off the absentee ballots, it must be separate from the regular line that regular voters or people going into the Board of Election office have to follow. The reason for that is presumably in New York right now, everybody who's receiving the ballot is supposed to be avoiding these lines. We're supposed to be avoiding prolonged contact with strangers. So you have to have that plan in place as to how you're going to get those voters in. That plan has to be submitted to the State Board of Election by September 21st. So that deadline is coming right up. With that, Pete, I am finished.
Thanks, Katie. Appreciate the update. We're going to turn now to an issue that a lot of people have been puzzling over ever since a court decision was issued, calling into question DOL's regulations. So we've got some revised regulations and some clarification from the DOL. Jessica and Teresa are going to take us through that. I think we're starting with Teresa, so take it away.
Thank you, Pete. Yes, as Pete said, we do have some updates from DOL. So, for those of you that weren't aware, and for those of you that need a quick reminder, on August 3rd, 2020, a judge in the Southern District of New York struck down 4 parts of the FFCRA regulations in a decision entitled New York versus United States Department of Labor. They had actually brought that lawsuit back in April, and it was decided in early August. And so what that did is it looked at 4 parts of the FFCRA regulations, which, as you remember, are emergency paid sick leave for COVID-19 and expanded FMLA leave for COVID-19 purposes. And so that 4 parts of those needed to be struck down. So there was an open question for a little over a month, really, about what DOL was going to do about this. Whether they were going to appeal the decision, and they still might, or, when they were going to issue revised regulations or guidance, or exactly what they were going to do. And then on September 11th, DOL released revised regulations directly in response to this Southern District of New York decision, kind of responding to the 4 parts that the court had struck down, as well as adding some clarification to some emergency paid sick leave reasons that I'm going to go over. But the revised regulations are effective immediately. So if these are issues that affect you, you need to make sure that you understand what the changes are and how they're going to apply to your business. So in the original DOL regulations, employees were not entitled to FFCRA leave, even if they experienced a qualifying event, such as being told to quarantine or seeking medical diagnosis, if the employer didn't otherwise have work for them to do. So if the employer had no work for them to do, there was no need for them to take FFCRA leave, even if they experienced that qualifying event. The court ruling said that employees are entitled to FFCRA leave even when their employers don't have work for them if they experience a qualifying event, or put another way, they said that the DOL's regulation on that could not stand. So DOL, in response to the court decision, declined to revise its original rule. It stuck by its original thinking and said work must be available for an employee to use FFCRA leave. So that's the update on work availability for those of you looking at that. Then the other part of the Southern District of New York decision concerned intermittent leave. If you remember, the DOL's original rule said that employer consent is required for intermittent leave under the FFCRA. So intermittent leave can be allowed. It's just that the employee and the employer had to both consent to the use of that intermittent leave. The court ruling said that the DOL's regulations on employer consent was not sufficiently explained by the DOL, and therefore employer consent could not be required for intermittent leave. In the DOL's response, they declined again to revise their original rule and stuck by their regulation that employer consent is required for intermittent leave. So that does appear to be their position on the matter, at least for the time being. However, and you'll see I put that in bold and underlined right there, there is a notable exception with the hybrid schooling scenario, and I'm going to leave it to Jessica to take you through that in much more detail. So the third area that the court decision had looked at was the notice and documentation requirements for FFCRA leave. And the original DOL rule, they had said that employers could require documentation of the need for leave for tax credit and for other planning purposes. The court ruling said that documentation could not be required as a precondition of granting the leave. DOL, in response to the court ruling, revised its regulations, and now it's revised to say that documentation can be required as soon as is practicable, not necessarily before the leave begins, but as soon as practicable. And then on a special note with notice, the new regulations say that notice of the reason for leave can only be required after the first day of EPSL. It can't be a condition prior to taking the leave. And then finally, the DOL responded to the Southern District New York decision on the definition of healthcare provider. If you remember, in the DOL's original rule, the definition of healthcare provider was very broad. It essentially meant that any individual who worked for a healthcare entity was a healthcare provider, and the importance behind that was that healthcare providers were exempt from the FFCRA, so EPSL and EFMLA did not apply to them. The court, however, and probably in the most expansive part of the court's ruling, they looked at the healthcare provider definition set forth by the DOL's original regulations and said that it was too broad to stand. So in response to that, DOL revised its regulations, and now healthcare provider is limited specifically to those employees who provide diagnostic services, preventative services, treatment services, and or other patient services that are integrated with and necessary to the provision of patient care. And very much like with intermittent leave, I'm going to turn it over to Jessica in just a minute so that she can explain in more detail what the new healthcare provider exception definition looks like. And then finally, the DOL added some clarification language to 2 of the reasons that an employee can take emergency paid sick leave. So they clarified reason number 3, which is advised by a healthcare provider to self-quarantine, and said that the advice to self-quarantine must be based on a belief that the employee has or may have COVID-19, that the employee is particularly vulnerable to COVID-19, and following the advice of the healthcare provider prevents the employee from being able to work. Please note that it also includes from being able to telework. Similar story with reason number 4 for EPSL. The DOL clarified that seeking a medical diagnosis for COVID-19 means that an employee may take leave if the employee has a fever, dry cough, shortness of breath, or any CDC-described COVID-19 symptoms, and the leave is limited to the time that an employee needs to obtain the medical diagnosis, such as waiting for test results or an appointment or attending an appointment to take care of the same. So that's a very broad overview of some rather particular regulations. I'm going to turn it over to Jessica to get into the more details about the healthcare provider and intermittent leave exceptions or changes.
Thanks, Teresa. So Kathy, if you can just go back one slide. I'm going to start with the healthcare provider definition for the purposes of the exemption, exempting out employees from the FFCRA. Now, don't forget, healthcare provider is used in different contexts within the FFCRA. And so what I'm talking about now is specifically limited to just where it's used for the exemption that you can apply to employees, not in other contexts. So as Teresa mentioned, the original DOL rule was very, very broad and essentially covered everybody from the highest ranking person in the facility, the direct care providers, all the way down to the sort of top to bottom approach within the facilities, the different healthcare facilities. The court ruled that that was way too broad and therefore could not stand, but also recognized that there could be still a broad definition applied that recognized the particular duties and responsibilities and services provided by specific classes of employees that would legitimize bringing that employee within an exemption and not having that person be able to take advantage of the FFCRA benefits. Now, one of the things that the court sort of latched onto in its definition is that it essentially covered, the original rule essentially covered even people who had absolutely no connection with the provision of healthcare, but just so happened to be employed by a healthcare facility. And that was a significant aspect of why the court thought that the original definition under the rule was too broad. So in response, I guess not surprisingly, the DOL sort of took a cue from the court's discussion and crafted a new definition that does recognize the need for particular employees or classes of employees to be more hands-on in providing the healthcare services to patients. And also, though, maintaining this definition to still be fairly broad in also recognizing that other people within a facility who might not have direct sort of hands-on treatment type services being provided still are integral to the ultimate provision of healthcare to patients, and so could be brought within the definition of healthcare provider for purposes of this exemption. So under the new rule, the DOL has said that those individuals who provide diagnostic services, preventative services, treatment services qualify for the exemption. And I'll get to the last piece in a moment. Those types of individuals are going to be the doctors, the nurses, the nurse practitioners, the physician assistants, all of the people within the different types of healthcare facilities that you would imagine provide the very direct patient care to individuals in those facilities. But it also includes not just on the diagnostic side, it includes the preventative treatment side, and it also provides just a more sort of day-to-day type of treatment as opposed to acute needs. So the direct providing of healthcare, still is a fairly broad definition, even under the new DOL rule. The last piece of the definition, though, this other services that are integrated with and necessary to the provision of patient care, recognizes that there's also groups of employees that don't provide a specific direct type of care, but also could still be integral to the provision of healthcare to individuals. And the Department of Labor, goes through a discussion and recognizes that individuals such as laboratory technicians who might be integral and necessary for processing test results, or as part of procedures, or other individuals. They mention, for example, X-ray technicians or other such individuals who assist with diagnostic tests and procedures. Although they might not provide direct care, they are going to be integral to the provision of health care. The DOL also grouped in this new definition individuals who may not provide what you think of as traditional health services, in terms of a diagnostic or a medical sense, but who nonetheless are integral in the sense that they provide services that, if not provided, would adversely impact the patient's care. And the Department of Labor uses, as a few examples, individuals who would be employed and do such things as bathing of patients, dressing patients, hand feeding, setting up medical equipment for procedures, the transportation of either patients or samples, and the taking of vital signs. So they listed out some of those individuals who also would fit within this integral aspect of the DOL's healthcare provider definition. And so even though this definition is not quite as broad as it used to be, it still is, a fairly broad definition where, we have to do a little bit more of a employee by employee or category of employee by employee type of approach to determine who might fit. But there still are a number of categories that would fit within this definition and therefore could be exempted from the coverage of the FFCRA. Kathy, can you go back 2 slides if you would? Sorry, one more. And now the other aspect that I'm just going to touch on with regard to the new rule in response to the court ruling is this issue of intermittent leave use. And so, as Teresa mentioned, the original rule was that an employer has to consent to an individual's use of intermittent leave under the FFCRA. The court said, hold on, you didn't explain it well enough, and so we're not going to let you require employer consent. And then the DOL responded by now further explaining its rationale for why employer consent is required, and stuck to its guns in terms of maintaining that employer consent is required for individuals who are taking intermittent leave under the FFCRA. However, there is this big exception, which I'll touch on in a moment. And so, to determine, intermittent leave use now under the FFCRA, you really need to look at 2 things, sort of a 2-step analysis. First, is this a reason, a qualifying reason where FFCRA leave could be used in the first place? And don't forget, the DOL has specified that where an employee is working remotely, Intermittent leave can be used for the variety of different reasons. And now under the DOL's sort of re-amplified response, an employee has to get the employer's consent to use leave in that context. But the other situation intermittent leave could be used is where an employee is unable to work remotely and has to actually report in person. The only qualifying reason where in-person work is required, the only qualifying reason that would you could use intermittent leave for is that reason number 5, the child care school closure reason. And so the DOL has now said that on the one hand, employer consent is required for intermittent leave use. However, the DOL also has now said that where school is closed or is operating in this, it's closed but operating in this hybrid type of situation where some days the school is open to the employee's child for in-person instruction, and on other days the school is closed to the child because the child has to get instruction remotely. In that type of hybrid context, the DOL is saying each individual school day is going to itself be a standalone qualifying event. And therefore, each individual school day is a new reason for why an employee needs or may need to take leave. And so where you have an employee who is using leave for, let's say, Monday, Tuesday, Wednesday, when their child is required to attend remote instruction, each day, Monday, Tuesday, Wednesday, are individual events. And so if an employee needs to take leave for Monday and Tuesday and Wednesday, that's not actually going to be viewed by the DOL as an intermittent leave use. And so in that context where we have a hybrid schooling scenario, employer consent cannot be required, is not required, because each individual day is viewed as a standalone qualifying event. So it's not being viewed as intermittent. Now, what I just talked about was where leave is being taken in full day increments. And so, there are still some potential issues that we would have to work through if an employee is looking to take leave in a shorter than full day increment. But the big takeaway here is for the hybrid schooling scenario, that is being viewed as the exception to the employer consent. So other contexts, employer consent is still required for intermittent leave use. However, just be mindful of this hybrid schooling scenario where employer consent is not required. And with that, Pete, I'll turn it back to you.
Thanks, Jessica. We're getting some questions on the scope of the healthcare provider. And I guess, obviously with each iteration here, we end up with, some more definition. But I guess the way I would parse this broad strokes is that we now have clarification from DOL after the court decision of what clearly meets the definition, and also some exclusionary language that says these things don't. To the extent that they are what I want to call support services within a healthcare organization. And then, but I think where the gray area is the sort of final thing is if you are, supporting the healthcare operations, whether or not you're going to be within the scope of a healthcare worker. Any thoughts on that, Jessica?
Sure. And so, there are going to be, sort of classification by classification analyses that have to be done. But there were certain groups of employees that the DOL identified as not falling within the exemption. just because their direct care or their relationship to that direct healthcare provision was too attenuated, even though they might still, have some relationship to the provision of healthcare. And so the Department of Labor identified specifically IT workers, IT professionals, maintenance staff, human resources personnel, cooks, food service workers, records management employees, consultants, and billers do not fit within the healthcare provider exemption, and so therefore would be covered within would be covered by the FFCRA. Now, that was not an exhaustive list that the DOL gave. That was a list of examples of employees who would not fit the definition. But I think it is instructive for that purpose.
Yeah, and then that third category are those who provide other services that are integrated with and necessary to the provision of patient care, and if not provided, would adversely impact patient care. That's where I think we're going to have the interpretive. We're going to have to look at it, on a case-by-case basis, and perhaps an organization-by-organization basis.
Correct.
Okay, great. Thank you. That's very helpful. And again, given the newness of this, I'm sure there's going to be a number of questions that people have, and that'll develop as we parse, the new guidance. Speaking of new guidance, as I mentioned previously, Erin's going to take us through some new EEOC guidance as relative to the COVID pandemic. Erin, take it away.
Sure. Well, now that everyone's head is spinning as a result of the discussion of the changes to intermittent leave and the healthcare provider definition, I have a much lighter lift. Jess, I'm sorry you got stuck with that portion of this webinar. So as Pete mentioned, last week the EEOC updated some of its COVID-related guidance that it put out back in March. So as I'm sure everyone on this call knows, there's a number of interactions between the ADA, the Americans with Disabilities Act, and some of our COVID obligations and some of the things that we as employers have had to deal with over the course of, I think we're on month 6 now. But I thought that I would take this opportunity to address, they added about 15 or so question and answers to this guidance, which can be found on the EEOC's website. But I wanted to highlight just a few that I thought would be beneficial, either because they're issues that you've been working through and it confirms what we have been doing, or it's things that you might be thinking about in the relatively near future. So the questions that or the issues that the EEOC primarily dealt with in its updated guidance concern wellness screenings, the confidentiality of the information gathered as a result of wellness screenings, and accommodations. So as everyone in this webinar, if you're a New York employer, know we've been dealing with wellness screenings for some time. Not everyone in the country has. So the EEOC did talk about the fact that wellness screenings are acceptable under the ADA, that this is an exemption to the medical examination rule, which really restricts an employer's ability to ask about an employee's medical condition, except within very limited circumstances. So the EEOC on the first point says, yeah, wellness screenings are okay. But there were 2 FAQs that they addressed that I thought would be beneficial to talk about here. And one of the issues that the EEOC mentions is, you as an employer, it's okay to ask everyone who's coming within your physical location, which is important to keep in mind. We shouldn't be asking those who are working remotely what symptoms they're having. But generally, if somebody's coming into your physical workplace, it's okay to conduct a wellness screening, and you can do it to everyone. But they warned about situations where you are not doing across-the-board wellness screening, and talked about a situation where you decide to ask one or two employees about certain symptoms, the EEOC advises employers, you have to keep in mind that you have to have a reasonable belief based on objective evidence that that person may have COVID. So if you're not doing across the board wellness screens because you're in a state outside of New York that doesn't necessarily require them, keep in mind that we shouldn't be treating people differently. And if we are, we have to have objective evidence and a reasonable belief as to why we're treating them differently. More interestingly, though, as we have developed our wellness screening questions, the EEOC advised that we shouldn't be asking in those wellness screening questions about family members. The EEOC has reminded us that the Genetic Information Non-Discrimination Act, or GINA as it's better known as, prohibits you as an employer from asking an employee about the medical information relating to a family member. So for example, if you have a wellness screening question that says, do you or have you or any of your family members exhibited symptoms of COVID-19? Under the EEOC's guidance, that is a question that should be revised. Now you can still ask, have you exhibited symptoms of COVID-19, or have you been in close contact with anyone who has also exhibited symptoms of COVID-19 or otherwise tested positive for COVID-19? You can still ask, have you been exposed to it, or anyone who's tested positive for it? We just can't limit it to the has a family member tested positive or exhibited symptoms. So I thought it was a very good reminder, and the reason that I'm mentioning it here. Another interesting point that I thought the EEOC made on here, for those who are transitioning employees back into the workplace from telework or remote work, if you have an employee who is refusing to complete a wellness screening or complete a temperature check, the EEOC has said that you do not have to allow them onto the physical premise. That means that you could, in theory, take disciplinary action if the employee is required to be on the physical premise. So something to keep in mind if you run into that issue. I would advise, talk to your favorite employment attorney before you make the ultimate determination. But generally, if an employee is refusing to submit to the screen, you may have an avenue for disciplinary action. The next topic I will transition to is the confidentiality of medical information that is obtained as a result of either wellness screenings or in relation to a COVID-19 event. So because we're dealing with a highly contagious disease, and we are trying to ensure the health and safety of all of our employees, a lot of employers have asked the question, well, what do I do if I have an employee who is exhibiting symptoms or is tested positive? Can I share that information with people? Who can I share it with? If you have a frontline manager who suspects that an employee is exhibiting symptoms or has been told that that an employee has been tested positive, that manager can share that information with the appropriate individuals within the workplace, meaning the director of HR or the health and safety person who is kind of the point person for these COVID-related issues. That is an okay situation to share that medical information. The other place that comes up is where you as the employer know that employees tested positive. You talk to that employee about all of their close contacts. Earlier on, I received a lot of questions from essential employers who were still operating. So for those who are still teleworking and moving towards returning to the physical location, you may or may not have had a positive COVID test that you've had to deal with yet. If you are in the bucket that hasn't had to deal with it, you'll learn that you have to contact trace. So you talk to the employee who tested positive, you figure out who they've been in close contact with, and then the question is, okay, what do I say to those employees who are in close contact? The EEOC prohibits us from disclosing the identity of the person who tested positive. So what that means is you can say to that group of employees, we need to let you know that you have been in close contact with someone who's either suspected of having COVID-19 or has tested positive for COVID-19. And then you advise them to seek medical attention and you follow whatever your health and safety plan is. Even if by, process of elimination, employees may figure out who the individual is who either exhibited symptoms or tested positive, you as the employer cannot confirm or deny whether their inclination is true. We cannot identify the person, but we do have an obligation, and it is okay to let employees know if they were in close contact with someone who exhibited symptoms or tested positive. Again, we just have to keep confidential who the employee was. And then lastly, the last topic that the EEOC addressed in this updated FAQ was accommodations. And there are a number of questions in here, but the one that I wanted to highlight, and frankly, it's a question that I've been getting a lot lately, and that is a number of employers went to telework and remote work, and many employers are still allowing some of that in their workplace. The question is, if you have an employee who is requesting an accommodation to continue to remote work or telework, do we now have to provide that accommodation because that employee has a medical condition? And it's really coming up in situations where we have employees who have medical conditions that make them particularly vulnerable to COVID. So if you have an employee who has asked to remain teleworking, the question that the EEOC has answered is, do I have to automatically continue that telework accommodation even though I'm requiring the rest of the workforce to begin coming back in? And the EEOC has said, no, not necessarily. It really depends. First, there has to be a determination as to whether or not that accommodation, the telework accommodation, really allows the employee to perform the essential functions of the job. For the past several months, employers may have allowed certain essential functions to go undone because, we're in a pandemic, and for the health and safety of people, they allowed a telework or remote work setup for a period of time. You don't have to allow, or you don't have to allow that employee to continue to not perform those essential functions. We can do a reassessment as to whether or not telework is a reasonable accommodation, even if it's been conducted for a period of time. But I would keep in mind that if an employee was successfully performing all of their essential functions during this period of telework, that may be a factor that goes into determining whether or not it is an undue hardship to continue providing that accommodation. I think as I've tried to advise employees or employers on this issue, it really has been a question in my mind now that we are so used to teleworking. Is the EEOC going to take the position that it is in and of itself a reasonable accommodation to continue to allow that? And they have said no. We have to continue to do a case-by-case assessment, taking into account the person's medical condition, whether or not that medical condition or disability requires or would be benefited by a telework situation, and whether or not they can perform all of the essential functions of their job. And with that, unless there's any other questions, Pete, it's back to you.
Thanks, Erin. A lot of interesting material there in terms of the latest from the EEOC. Lastly, this afternoon, we want to turn to Kurt Johnson. Kurt's in our Rochester office, and he's just going to update us on what's going on out there on the litigation front, theories that are being espoused, potential liability that's being asserted, things of that nature. Kurt, please take it away.
Yeah, so I'm just going to tell you really quickly about maybe some new COVID litigation you've never heard of. Dan Pouts, one of my partners in litigation, was on a couple weeks ago and told you about some class actions relating to small businesses suing banks for PPP loan issues, favoring certain customers over others, price gouging, issues about ticket and membership reimbursement. labor and employment litigation, and tuition reimbursement in higher education. I did want to provide one quick update on the labor employment front. It's an interesting case out of Buffalo. The Buffalo Teachers Federation is seeking injunctive relief in connection with an arbitration, trying to avoid having to come in person to work for the entire Buffalo school district. So that's ongoing. They sought a TRO, and that was denied. Ultimately, now they're seeking a preliminary injunction. And that's being litigated. So interesting categories of COVID litigation. There's one involving Purell and Germ-X hand sanitizers. Even before COVID, the FDA told Gojo, the maker of Purell, that it should stop claiming in its advertisings that hand sanitizer could, quote, reduce or prevent diseases, including Ebola virus and the flu. Now that we have COVID, the question is, what can they say about its ability to prevent COVID in their advertisings? We know that, or we're starting to learn that COVID is spread more through droplets in the air than surfaces that we touch. But it's a little bit of a gray area. And if people get COVID and then they say, hey, I lathered myself from head to toe in hand sanitizer, how did I get COVID? Maybe they have a false advertising claim. So that's being brought as a class action. We're also seeing and going to see litigation over the sufficiency and efficacy of masks and other PPE, including people bringing personal injury and wrongful death claims, saying, I use your product, I use it as advised, it didn't save my life, or didn't prevent me from getting sick. It'll be interesting to see if there's causation issues there. Were they wearing the product every moment of their day? What other things were they doing incorrectly, like touching their face when they were using a mask, things like that. So it'll be a challenge for those parties to seek recovery, but it's not impossible. We're likely to see an influx of additional wrongful death and personal injury cases against nursing homes. So initially, back in March, as part of the state budget, there was a protection enacted for healthcare workers. Basically, healthcare workers who arrange for care of anybody relating to COVID were free from liability absent their own gross negligence. And gross negligence is a very high standard. It's not mere making a mistake. It's a lot higher than that. We saw a lot of deaths in nursing homes. One source I saw said that there was 6,000 deaths in nursing homes in New York. The plaintiffs bar and plaintiffs themselves want to go after nursing homes for their failures to protect patients who maybe didn't even have COVID to start with, but were placed next to somebody in a room next to somebody that had COVID. And so the state legislature got to work and they made an amendment. They changed the definition of healthcare provision from arrangement to I'm sorry, I lost my spot. Basically anyone who arranges care for non-COVID people, non-COVID patients who are also in that facility, they can now be liable if that person gets COVID without the gross negligence bar. But that went into effect August 3rd, and most of the people who got COVID in New York State got it before August 3rd. So it's really a going forward protection, or not protection if you're a nursing home, protection if you're a patient. And additionally, plaintiffs are seeking and pursuing cases that had happened before March. So people died of COVID before this law went into effect. And there's a number of lawsuits out there. Plaintiffs attorneys have drafted hundreds of complaints and gotten those filed. And there are also plaintiffs attorneys who can prove gross negligence are actually now pursuing gross negligence claims against nursing homes if they can show that the nursing home really dropped the ball, not just made a mistake. We're seeing claims relating to mask requirements coming out of other states. There's a group of plaintiffs in Pennsylvania who are parents of children with autism and muscular dystrophy, and they're suing amusement parks who are requiring visitors to wear masks, saying that the amusement parks are discriminating against the autistic and muscular dystrophy patients that otherwise want to go but can't wear a mask because of their medical issues. So that is in very early stages of that litigation. The complaint's been served, but there's not been an answer. We don't know if they're going to move to dismiss. It'll be interesting to see how that works out. A piece of litigation that I find extremely interesting, although it's not really going anywhere, a group out of New York City called the Brain Injury Rights Group sued every single school district in the country. They also sued all 50 state departments of education, seeking to compel them to reopen every single school in the country, saying that they represented a group of 104 plaintiffs, parents, and children, children with disabilities, who were being denied a fair and appropriate public education because they had disabilities and their individual education plans, IEPs, were not being met because they were receiving virtual instruction as opposed to instruction at home. Now, there's a lot of problems with this lawsuit. Some of them have to do with procedural issues. So can you sue 12,000 defendants, 13,000 defendants that are school districts across the country? Not really. The Judge Colleen McMahon in the Southern District of New York, as soon as she got this case, basically took hold of it and said, I don't think I have jurisdiction over 49 of the 50 state school districts because they aren't present here in New York. They don't have a connection to New York. How can you sue them here? So the plaintiffs are facing that issue. For school districts outside of the Southern District of New York, which is generally Manhattan and some of Westchester and other surrounding areas, there's questions about whether school districts outside of those areas claims against them are properly venued in that district. So again, the judge required the plaintiffs to submit argument as to why the claims were properly in her court. And having reviewed the submissions, I don't think that they'll ultimately persuade the judge that she should be deciding on these issues. So do I think an injunction is coming to make every school district open in the state? No, I don't. Or in the country? No, I don't. But New York City is involved in this litigation. It'll be interesting to see what happens in New York City schools. And then recently, the state of Ohio and other states are addressing legislation aimed at providing very broad protections for businesses in connection with COVID liability. So one such Ohio law is looking at statewide immunity for civil lawsuits claiming injury, death, or loss based on the transmission or contraction of coronavirus. And it would significantly limit exposure to Ohio businesses under state law. They can still be sued under federal law theories, but most theories of liability would be under state law, so generally protecting them. It would also shield healthcare providers and limit tort action for provision, withholding, or withdrawal of health services relating to COVID. And it would bar class actions, completely bar class actions relating to healthcare provider or business or government entities that cause exposure to COVID. New York is unlikely to pass this kind of law, especially since they're repealing some of the protections they put in place for healthcare workers. It seems like we're going the other direction in New York, but something to keep an eye out for. You may have federal or state law coming that protects you from, concern about getting your employees, your customers, and any other visitors sick.
So Kurt, thanks. I guess my summary would be this, that, we have to continue to act as prudently and reasonably as we can in every facet of, what we do. If we follow the guidance and do the best we can with the plans, that we're going to insulate ourselves to a great degree from liability. There's also, as you point out at the very beginning, the causation question, which is always going to be an issue. So, but it's interesting to periodically explore these things just to see if we've got any blind spots. I want to thank everybody for being with us today and for being with us every Tuesday. We very much appreciate the opportunity to spend a few minutes with you. Everyone, please stay safe, and we'll talk to you next week.